Michael is going to tell you who got in. I'm here to talk about what happens when a school believes it got left out for reasons that do not match the rules it was told to trust. Selection Sunday is one of the strangest rituals in American sports. Everybody acts like it's half science, half vibes, and maybe a little television incense burning in the corner. But officially, for the men's tournament, this is a 12-member committee selecting a 68-team field made up of 31 automatic qualifiers and 37 at-large teams. Now, the NCAA says the committee is supposed to watch games and analyze team sheets, apply conflict of interest rules, use secret ballots, and follow established selection principles. So this is not supposed to be a random act of basketball weather. It is supposed to be a process. And that matters because when you have a real process, you also create the possibility of a real challenge. Now, not every snub is a lawsuit. Most are just pain with a jump shot attached. But when a school can plausibly say, you published the criteria, we built a resume that fits those criteria, and then you did something else, well, now we are no longer in pure bracketology. Now we are at least peeking over the fence into legal territory.
You're listening to the AAA Ball and Play podcast. Quick note, this is for education and entertainment. Nothing here is legal, tax, or financial advice, and nothing we say creates an athlete-agent relationship. Listening or contacting us does not make us your lawyers or your agents. For advice, talk to a qualified professional in your state.
So let me make one correction right at the top, because legal precision matters and loose phrasing is how nonsense grows legs. The phrase arbitrary and capricious comes from administrative law and judicial review of government action. The NCAA, however, is not government action. The Supreme Court in Tarkanian treated the NCAA as a private actor, not a state actor. Now, you may feel that the NCAA is a quasi-government agent, as I do, but that's not what we're talking about today. That's a side quest that we're not going to go down. So if we use arbitrary and capricious here, we are using it as an analogy for irrational, inconsistent, or bad faith decision-making. It is not a magic wand that automatically imports the Administrative Procedure Act into March Madness. And a shout out here to Judge Spindon for teaching us admin law in law school. So anyway, it's a cute phrase, but it's the wrong mailbox. That said, the analogy still helps explain the problem. Now, courts are often reluctant to interfere in the internal affairs of private associations. This is America, but they have recognized room for review where an association acts arbitrarily, capriciously, in bad faith, or contrary to its own rules. And that is the pressure point. The issue is not my fans are mad. The issue is, did the association apply its own framework in an even-handed way when real financial and competitive interests were on the line? Which brings us to theory number one, the so-called arbitrary and capricious problem. Now, the trap is not that the committee evolves. Committees can refine metrics. The trap is when the committee appears to move the goalpost inside the same season, applying one logic to Team A and a different logic to Team B without a coherent explanation. The NCAA's own materials say conference affiliation, brand mythology, and television networks are not supposed to decide the bracket. If a left-out school wants to make noise, the smartest argument is not we got robbed because we're a mid-major. It's your treatment of comparable resumes does not line up with your own stated process. And let's talk about the TV ratings line because it is emotionally satisfying, but it is legally dangerous. The NCAA publicly says broadcasting networks have no involvement in the selection process. So today, on the public record, you should not present TV did it as a fact. Present it as a hypothetical. If a school ever uncovered communications showing broadcaster-driven pressure overriding published criteria, that would be a serious problem. But without evidence, that claim is still in the parking lot doing donuts, if you will. Now, the second theory is the contract of membership argument. Now, the NCAA's rules are adopted by member institutions. Courts have long recognized that the bylaws of a voluntary association can function as a contract among members. A school could try to frame the case this way. We paid dues, we complied with rules, and we had a contractual expectation that championship access would be governed by the rules the association itself adopted. If a school can show a material deviation from those published procedures, a breach-style argument becomes plausible. And we have seen courts step in around NCAA decision-making when the allegation is bad faith. We've seen that a lot, right? The Trinidad Chambliss case in Mississippi wasn't a tournament seeding case. It was an eligibility fight. Still, it is a useful reminder. A judge granted Chambliss an injunction after concluding the NCAA had shown bad faith by ignoring medical evidence. Now, that doesn't mean a Selection Sunday challenge would win, but it means that courts are not mythological creatures that vanish whenever the NCAA speaks in a stern voice. But you don't get drunk on that too quickly. Emergency relief is hard. A recent Florida appellate decision in another NCAA eligibility case quashed a temporary injunction, emphasizing that injunctions are extraordinary remedies. So yes, you can say TRO on camera, but say it like a lawyer and not like a wizard. A court is going to ask, what is the legal claim? What is the proof? Why are money damages not enough? And can you explain all of that before the bracket becomes a living, moving event? That's a brutal clock. So let's talk damages, because this is where the snub, so to speak, starts costing actual money. In men's basketball, tournament units are distributed to conferences on a 6-year rolling basis. In women's basketball, the units are distributed on a 3-year rolling basis, and the women's fund just began paying out in 2026 based on the 2025 tournament. Now, exclusion affects conference distributions in a real measurable way. That's not fan melodrama. That's not fan melodrama. That is economics. A school could also try to quantify downstream losses in ticket demand, sponsorships, and the broader recruiting and NIL environment. A wrongful exclusion is not just bruised ego in a mascot suit. It is a business event. That is also why I would be careful with tortious interference. I understand the instinct. This exclusion interfered with the school's economic prospects. But under Florida-style tortious interference principles, that tort requires the defendant to be a stranger to the business relationship. If the tournament committee is part of the relationship being challenged, that theory gets incredibly hard. Treat it as an outside possibility, not your headline. The headline is association law, bad faith, or contract-based reasoning. So if I were advising an athletics director before Selection Sunday, which is now past, I would build a clean record. I would map the team sheet against the published criteria. I would get the finance people ready to quantify damages immediately. And I would evaluate emergency relief fast, understanding that the legal runway here is brutally short. The final point is this: a Selection Sunday snub, and we've heard news this morning on Monday, right, about plenty of people that feel teams were snubbed. A Selection Sunday snub is not automatically a lawsuit. Most of the time, it is just the cruelty of comparative resumes. But a snub becomes legally interesting when the claim stops being "we deserved it" and becomes "you published a process, made us rely on it, and when the stakes were highest, you did not apply it evenly." That is the moment when the bubble leaves sports talk radio and wanders into a law office. Michael's telling you who got the bids. I'm telling you what happens if one of those missing schools decides the bracket was not just unfair, but unlawfully so.
You're listening to the AAA Ball and Play podcast. Quick note, this is for education and entertainment. Nothing here is legal, tax, or financial advice, and nothing we say creates an athlete-agent relationship. Listening or contacting us does not make us your lawyers or your agents. For advice, talk to a qualified professional in your state.